What if I told you that there's a way to discharge debt by combining two powerful tools, your trust and your coupon? In this video, I'm going to break down how to use trust law alongside coupon remittance to create a private lawful discharge and how to structure it step by step so they can't just ignore your offer. Now, study trust law, UCC, administrative remedy, and I'm here to show you how your trust can be the perfect legal shield for discharging public debts. Now, before we dive into this video, this is not legal advice. This is not financial advice. Okay, this is only for educational purposes only. So I suggest you do your due diligence, no matter whether you watch this video all the way to the end and you feel confident after watching this video. Make sure you do your due diligence. Don't take everything that I say for face value. You dig me? Now, also, if you're brand new, hit the subscribe button, hit the follow button. You dig me? Hit the like button, because we want to be on the top of the algorithm, because nobody is talking about this. You dig me? So I'll give you an opportunity to do that right now. I bet. Now, some of the things we're going to be talking about today is why to combine trust law with remittance. You dig me? We talk about remittance all the time on this channel. We're going to talk about how the trust acts as an authorized remitter. Okay, and we're also going to talk about how to structure the remittance packet so that you can properly endorse and enforce your remittance coupon. Okay, now I think one of the biggest things, because we talk about remittance and we talk about remittance from the aspect of you communicating with the debt collector as the debtor, but what we're going to talk about is how you're going to be able to utilize the trust model to be able to give yourself a different positioning as it pertains to discharging debt. It gives you more leverage, because now we're not just falling under the UCC. Now we're using the aspect of equity, and we'll talk about that as we go on. Now, let's dive straight in. Okay, why to combine trust law with remittance? Okay, now for those of you guys who don't know what remittance is, I'll go ahead and pull up my screen real quick. What remittance is, you dig me, is a payment or money transfer from one person or entity to another, often involving a sum of money sent or transferred, and it can be a payment towards an invoice, a gift, transfer of funds, especially between countries, often for migrant work, blah, 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 blah. It also says remittances can be used to pay bills, support family members, and provide funds for various needs. So long story short, remittance is a lawful tender. Dig me? If I bring up the definition of tender, Cornell law, get me? Okay, bet. So tender, by definition, is to unconditionally offer money or performance to meet an obligation. So why do I talk about this? The reason why I pull this up is simply for the fact that one of the arguments that debt collectors have is they'll come and they'll say, well, you got to pay in lawful tender. But to you, you think that tender is only the fiat dollar, the Federal Reserve note, the dollar bill. But it says here, the definition is to unconditionally offer money or performance to meet an obligation. So if they were to come to me and tell me that I can only pay in legal tender, then you're literally saying that I can only unconditionally offer money or perform to meet an obligation. And that can be anything. You understand me? Now, understand that remittance equals performance under public policy. And this is based off of House Joint Resolution 192. It's based off of other public policies as well. But just on the premise of House Joint Resolution 192, I'll pull that up real quick, just for the record, just so you guys can see it. For all my new people, okay? House Joint Resolution 192, you can literally look this up. Long story short, this was enacted in June 5th, 1933. Congress enacted House Joint Resolution 192 to suspend the gold standard and abrogate the gold clause. This resolution declared that whereas the holding and dealing in gold affect the public interest. Okay, skipping ahead, it says this resolution declared that any obligation requiring payment in gold or a particular kind of coin or currency or in an amount in money policy, and every obligation herefore or hereafter incurred shall be discharged upon payment dollar for dollar in any coin or currency which at the time of payment is legal tender for public and private debts. So I bring this up. Number one, this was enacted almost 100 years ago, and we're still in a matrix thinking that what we have to do is pay debts, but the reality is that we have to perform. The reality is we just have to record our certificate of indebtedness. Understand me? So because of House Joint Resolution 192, they had to create things like remittance. They had to create things like discharging debts. They had to create different ways to perform on debt contracts because there was no real money. All right. Now let's just talk about the aspect of a trust. Okay. A trust equals a private entity. Okay, hold on, let me see if I can pull it up on Cornell Law. Okay, they don't have exactly where I want to go. We'll just take the Google definition. This is a trust. A trust is a legal arrangement where one party, the trustor, the settlor, and the grantor transfers the ownership of assets to a secondary party, the trustee, for the benefit of the third party, the beneficiary, and the trustee holds, manages the assets according to the terms of the trust document for the benefit of the beneficiary. So long story short, when you look at a trust model, there is the person that creates the trust. You dig me? Then along with the person that creates the trust, there is a trustee that they then give the responsibility to manage the trust. And then there's the beneficiary who gets all the benefit. So typically we only know about this in wills and you know, life insurance and things of that nature. But when you are creating a private trust, you can actually be your grantor, trustee, and the beneficiary. Okay, and you can also assign your debts to your trust so that now all the debts are at your personal name and is now assigned to your trust. Your trust doesn't have to necessarily be tied to you in a sense, like it doesn't have to be named after you. And now the debt collector now has to communicate with the trust. Okay. And when you do this, this now puts them in a position of utilizing or having to use equity. And when I say equity, I'm talking about fairness when it pertains to that contract. So the trust equals a private entity that protects, controls, and enforces the rights. Now, when you combine these two, okay, it can equal powerful separation between the debtor and administrator. You dig me? This is why you could utilize a trust. All right. So let's just talk about the trust. When you're using the trust in the remittance process, the trust now becomes the remitter. You guys gather that, okay? The trust now sends the lawful tender via coupon, bill of exchange, etc., etc. And this keeps the admin process off of your personal name, okay? Once you assign that debt to the trust, it actually should be out of your name, okay? Yes, you may have to send them a notice and say that, hey, we assign this debt to you know, X, Y, and Z trust, but your trust holds the pen and you hold the power because yes, you can still have control over the trust and you can still have ownership over the trust, but it isn't tied to your name, okay? You're actually hidden, okay? And this is super important because a lot of times when you are attacking the debt collector as a debtor, they're going to treat you as such. They're going to treat you as if you owe a debt instead of treating you as a business entity doing business with another business, negotiating and settling about the debt. Okay? You can open up a trust specifically for debt settlement. Okay? Now, I do have a video on how to create a private trust, and I may talk about that a little bit depending on the time frame. But let's just dive into how the trust acts as an authorized remitter, okay? So first things first, you want to establish a private irrevocable trust, okay? How you create a private irrevocable trust is you have to create that trust through, you got to create your own private declaration first, okay? You don't just go to the IRS, create your irrevocable trust, because then now it'll become a public trust. You want to make sure you create that trust privately, and right when you create it privately through your own declaration and your own paperwork, then you then get an EIN for that. Okay? So when you do that and you create that private irrevocable trust, I do have a video. I'll do that link in the description so you guys could be able to see how to put that together. It's also in the complete debt guide. So if you tap into the complete debt guide, you'll be able to see exactly how to that step-by-step process on how to create your own private irrevocable trust. But when you do this, the trust becomes the secure party or the authorized administrator. You understand me? So if it becomes the authorized administrator, now that is the person doing the admin work for your debt itself, okay? Just like if a law firm were to take over somebody's debts, whatever the case may be, and they are now communicating with you on behalf of Capital One or whatever the case may be. It's the same exact thing, all right? So when you do that, you want to make sure to sign the remittance and use conditional acceptance as the trustee or agent of the trust. All right. So this is what the trust will send. The trust will send the coupon. The trust will send the letter of endorsement. The trust will send the notice of tender. The trust will send the affidavit of truth. The trust will send the conditional acceptance, all on behalf of the trust. Because remember, the debt is now assigned to the trust, but it doesn't change the fact that you have to still communicate about this. Some people think that they're going to just assign their debt to the trust and not, and they will skip over the administrative process. They think that having a trust is going to eliminate them or wipe them away from having debt, but you still have to negotiate it. It's still a contract that needs performance. Okay, and if it's an invalid contract that doesn't need that you believe doesn't need performance, you have to make sure to perform in a way that invalidates that. You want to make sure that it is completely void before you just say, oh, I'm not going to do anything for this contract. All right. So when the trust speaks, it creates a layer of lawful protection and commercial clarity. Okay. So you want that protection so that you can be able to communicate with the debt collector and the debts don't necessarily show up on your credit report. You can easily argue that the debt is not yours. You can easily argue that the debt belongs to XYZ Trust. And that's just another way, another loophole to say, all right, bet there is no debt tied to my name. Okay. That's one of the key benefits of having a trust, because the trust will protect you. All right. The next thing, how to structure the remittance packets. Okay. Make sure you guys are taking notes, okay? Especially if you're interested in this, make sure you guys are tapped in and taking notes. If you want to typically learn how to do the remittance process, make sure you are taking notes. Make sure you hit the subscribe button. Make sure you hit the like button, because we're about to show you how to structure the remittance packet. Something that people think I know that people are not doing, sending with their remittance, okay? What they are just doing is sending the coupon and hoping for the best. But what I'm about to talk about is what you should be putting in there in your packets, okay? Now, I see you. I'm going to answer questions at the end. Now, this is what you want to do with this is the packet you want to send. Number one, you want to send a cover letter from the trust, just outlining exactly what is in this packet. Number two, you want to send the coupon with the signature, accepted for value through the trust name. Okay, you want to make sure to use the proper endorsement under 31 CFR 328.5. You understand me? 31 CFR 328.5, forms of endorsements. Okay, for presentation to the Federal Reserve Bank of. You want to swap this out for the United States Treasury. If one says, okay, but how do I put this together? I mean, you come here, it's going to tell you exactly what to do, how to properly endorse it. You come to this next page to show you exactly how to do it as well. It tells you how 4 inches in width, 1.5 inches in height must be imprinted by a stamp or a plate, right? It should be on the left edge of the security, okay? It tells you when securities are to be presented to the Bureau of Fiscal Service, the words United States Treasury should be used in lieu of words Federal Reserve Bank of Fiscal Agent of the United States. So it tells you exactly how to put this stuff together in 31 CFR 328.5.6. Okay. So I show this so that, there is no confusion. I think a lot of people look at or listen to the content and, I'll even get on the phone with some people and it's almost like, did you even read the law? This is why I be hopping in y'all ass. Read the law. Be okay with reading the law, my baby. Okay. So along with your coupon and your endorsement, you want to make sure to send an affidavit of tender and a conditional acceptance. Now you can look at all of these terms online. Affidavit of tender, conditional acceptance. If you watch my YouTube videos, we all know what affidavit of tender is and conditional acceptance, or it could just be a notice of tender, okay, for other words. You also want to send a notice of reservation of rights. Now, you're sending all of this through the trust under UCC 1-308. You can also optional, you can send a money order or a promissory note. It's not necessary, but it does enhance your, it makes your, it just gives that tender more weight. Okay, babe, you're not going to take the coupon, then boom, I already created a promissory note and money order, promise to pay, unconditional offer. I already created another negotiable instrument. So, and then you want to put the return address of the trust. Make sure your trust isn't tied to your home address. Okay, make sure your trust address is tied to an actual address outside of you. Okay, you want to send it certified or registered. Registered, obviously, it's insured, but you could just send it as simple as certified. And you want to create and store the administrative record somewhere safe. You understand me? I think that's the part that gets missed. People will do the work, but they won't keep copies and save it and put it in a place, because if you get in a place where it's like, all right, bet, I've been sending them letters over this amount of time. I always tell people, okay, bet, why haven't you taken them to court yet? If you review what you have sent them and you review what they have sent you and you understand the process enough to know that they are doing you wrong, just take that evidence to court. Well, I don't know how to file. Okay, bet. Well, that's when you go to small claims or you go to your county clerk and you ask them how to file. You can literally go on Google and type in, how can I file my case in small claims? How can I put together an administrative lien? All of that is, well, I did talk about that in my previous video, so go tap into that. All right. So understand that this is more than just a letter. This is more than just a coupon. It's performance under law backed by a lawful structure. So notice how I said 5 documents, 5 affidavits, the cover letter, the coupon, the notice of tender, the conditional acceptance, reservation of rights, money order or promissory note, and you want to make sure to put whoever you want it to, or whatever address is connected to your trust on there. All right, so it's a full packet. Now, here's what to do after sending. Okay, you want to wait 10 to 14 business days. All right, 10 to 14 business days, or you can give them 30 days, depending how much. If they ignore, you escalate using the administrative process, my baby. You want to use notice of fault plus the opportunity to cure. You give them the opportunity to cure, especially all of this has even more weight when you're doing it through a trust. You give them that notice of fault and the opportunity to cure. You're essentially saying, hey, you are at fault. Here's your opportunity to cure your fault. This is like giving them a second chance. Then if you give them a second chance and they still do not comply, they still are acting like they don't know what you are talking about, you don't have to explain anything to them. You just want to make sure to put a notice of default in dishonor. Okay? When you go to UCC 3-505, I believe, it talks about the aspect of evidence of dishonor. Okay? When they reject or they ignore your lawful tender and they do not provide the reasons why, and they're valid reasons, then they are dishonoring you. Okay? And then you want to also send an affidavit of non-response when it gets after the default and dishonor. You want to send that affidavit of non-response, and you want to, this is the case that you're building of them being in violation. Now, you want to keep everything in your trust private remedy log. Okay, and optional, you want to use this to prepare for a lien. You want to use this to prepare for arbitration or small claims enforcement. Now, obviously, you can get to a point where they'll stop sending you letters. They may leave you alone. They may cease collection, whatever the case may be. But if this stuff is still in your credit report, they're still in violation. Okay, you can also take this evidence and send it to the credit bureaus and show the acquiesce, show the silence to the credit bureaus. Okay. So I want y'all to understand that the goal isn't to beg for approval. It's to show that you offered remedy and they failed to respond lawfully. Do you guys gather that? Because the thing is, when you start to ask for permission, this is when they take away your rights. You actually take away your own rights when you start to ask for permission. And that's the problem. If it is your right, you don't have to ask for it. That's why certain aspects of, you know, voting and politics and things in that nature, where when we're asking for rights, we're literally giving them all the power. Why would you ask somebody for, like if you lived in your own home, okay? It's just like asking your parents, can I go to the bathroom, and they live in another state. It's almost like you still giving them the power. There's nothing wrong with doing that. Respect your elders. But for something simple like that, or can I go out? Can I invest in a business? I got to talk to my mom first. Okay. So we unknowingly give away our power by literally just asking for permission. I'm telling you not to do that. I'm telling you to move in honor, initiate, and it's up to them to respond in a lawful way. It's not up to you to teach them the law. They should know this. They have $1 million business, so they should know the law. If you are a licensed debt collector, then the Fair Debt Collection Practices Act should be one of the first lessons. You dig me? If you wanted to get like the stamp for the coupon, then all you have to do is go to rubberstamps.com. Okay, just throwing that in there. All right. So trust and coupons weren't designed to be just some cute paperwork. That's why I give you guys templates, whatever the case may be. And it's not to just be printed out, filled in, and just sent out. It's really given to you so that you can overstand the information. Forget understanding. Forget standing under somebody. Overstand the information. Okay? Because they were designed to discharge debt and perform under public policy. And if you use them right together, they become an unstoppable remedy. So if you fully not only use them, but you understand them, overstand them, then you will be in a position of where you have so much confidence in what you send these companies, send these people, to the point where, okay, bet, like, I love to get a non-response from a debt collector. I know that in law, that whatever I put in my letter now stands in truth. And even better when you're sending it through your trust. Notice how I said the same exact process, but I just included sending it from your trust. It creates more power. It's not needed, but it's an extra layer of protection. Okay? So set up your trust. Okay, take your time on it. Don't feel like, oh man, that's the first step I need to take. You can start challenging some collections right now without a trust. Some of them don't need that complicated process. Some of them just bought your debt, have your information. A simple debt validation letter, conditional acceptance will put them in a position where now the burden of proof has been shifted onto them and they have no choice but to comply or get sued. Okay, I was talking to an attorney and she said that attorneys charge these companies upwards to $1,500 an hour. So do you think that, and these things can go on forever. So do you think that if you do your proper paperwork and you can show to them that you're going to win and that you want 10 grand, you want the maximum of small claims, you think that they're not going to just settle on a 10 grand? Or better yet, just say, all right, bet, our hands are free. Our hands are off this. Go ahead. We don't want the low 1,000 because some of us have $1,000 debts, $2,000, $3,000 debts, but they're going to pay their attorneys way more than that. To what? Fight a $1,000 debt? But this is where they win. They win when you do not respond, when you do not initiate, when you do not take action, my baby. But I'm rambling on, okay? Make sure you guys tap in to the Complete Debt Guide if you want to learn how to build a trust, if you want to learn the step-by-step process or how to be able to communicate using a trust, if you want to know the step-by-step process and have the templates to put those letters together, go ahead and tap into the Complete Debt Guide. It will be in the description down below. You also become an affiliate. So if you do get the Complete Debt Guide, you will be able to, resell it to other people that are interested, okay? Now, this is for my people who already tap into consumer law content and courses and are going to resell it anyways. Let's just do it the proper way. So I'm not against anybody using my material or even talking about material on their own page. I really don't care. Everybody can eat. But what's going to happen is that mass awareness, and it's going to start empowering people to start taking action. More of us take action than we actually build a true revolution based off of facts and truths instead of something theoretical, something emotional. All right, so tap into the Complete Debt Guide. Number 2, if you want to work with me one-on-one, down below there is the mentorship link. You have to be serious about your business. You cannot get on the phone with me and want to ask me 1,000,001 questions about your particular situation. I probably either won't answer depending on your questions, and number 2, if I do answer, I'm going to keep it short and sweet. And I'm going to direct you to my consultation call. If you want a consultation one-on-one, just tap into, if you want that one-on-one consultation, just tap into my Instagram, DM me and ask me about that one-on-one, okay? On that note, follow me on Instagram at biz.nick. You dig me? If you want to be updated on the YouTube videos, you want to be able to connect with me on a more personal letter, tap into biz.nick. And lastly, tap into the Twitch. You know what I mean? I mean, we live on Twitch. I literally created this on Twitch. So if you want to see these breakdowns live, tap into the Twitch. The links will be in the description. Dig me? Same thing for you guys that's on the YouTube live. We got 39 people in here. We should have 39 new followers by the end of today. Okay? And my last question is, have you ever tried to send out a private trust? Comment below. I'll help you map it out. And remember to like, subscribe, turn on the post notifications because public debt requires private remedy. I love you guys, and I'll see you next time.